this video, we are going to consider the processes and procedures that should be followed when a PAIA request is made and submitted. Now, a PAIA request is made and submitted to a local municipality where hopefully there's an information officer who is there to receive the PAIA request. As previously stated, a PAIA request to a public body should be submitted on a Form A. Once an information officer has received a Form A, they have the duty to acknowledge receipt of that Form A. That acknowledgement is done through either an email, telephone, or any other necessary means. The information officer also has the duty to look at the Form A that has been submitted and determine whether there is fees that are applicable. If fees are applicable, then the information officer must send a fee notice along with the relevant banking details to allow the requestee to pay the fee amount. And then the information officer begins the process of trying to locate the records. If the information officer searches through the records and determines that actually these records do not exist in our office but are held with another public body, then in terms of Section 20 of PAIA, the information officer has a duty to transfer that request to the relevant public body within 14 days. Once this transfer is made, the information officer has a duty to inform the requestee of this transfer, and then the requestee can now follow up on their PAIA request with the relevant public body. If the information officer locates the records and determines that actually the information that is contained in the PAIA request affects a third party, then in terms of PAIA, they have a duty to issue a third-party notice. This third-party notice must be issued immediately as soon as the information officer realizes that third-party information is contained, but must be done within 21 days of receiving the PAIA request. Then the third party is afforded 21 days in which they can make representations as to whether they have any objections to the information to the records being released to the requestee. If there is any issue of extension of time, then that extension of time must be communicated to the requester. Now, if an information officer does locate the records and determines that they may need a little bit more time to process the records, then in terms of PAIA, they have the option to send a notice of extension to the requestee. This notice of extension must inform the requestee that they are in fact processing the PAIA request, but are simply requesting to do it in a longer period of time. This notice of extension must be sent before the 30 days is over from the date of submission and cannot be longer than 30 days after the 30 days of submission expires. Meaning, if an information officer requests an extension of time, then essentially the maximum amount of time they will have to process it is 60 days. If the records are located and either the third-party notice is relevant and these two are not relevant, then the information officer has 30 days from date of submission to take a decision. There are four main primary decisions that an information officer can take. The first one, and hoped for one, is that the request is granted. Once a PAIA request is granted, the records are released. The second decision that can be taken is that an information officer, after searching for records, can find that the records cannot be found or they do not exist. If the information officer finds that the records cannot be found and they do not exist, in terms of Section 32 of PAIA, they have a responsibility to submit an affidavit stating that. The affidavit must make it very clear the steps and measures that were taken to locate the records and serves as a confirmation that the records in fact do not exist. The third response that an information officer can take is to refuse to grant the request. In order to learn more about the grounds for refusal, please refer to our previous videos that explain these grounds. Once an information officer refuses to grant a request in terms of any grounds under PAIA, they have the responsibility to notify the requester. They must notify the requester clearly of the decision to refuse to grant access to the records. They must clearly articulate what their reasons are, as well as specifically say what sections of PAIA the refusal is based on. An information officer must also ensure that they inform the requestee of their right to appeal this decision if the requestee does not agree with the grounds relied upon for refusal. And the last and very unfortunate way in which a decision can be taken is in terms of Section 27 of PAIA, where the information officer completely fails to respond to the PAIA request at all within the 30 days of submission. This type of refusal to respond is deemed a refusal in terms of PAIA. This means that by failing to respond, the information officer has essentially denied access to the requested forms. If the decision taken is either that the records cannot be found or do not exist, or it is a refusal to grant records, or it is a deemed refusal because there was no response issued, then the requestee, in terms of PAIA, has the right to submit an appeal to appeal the decision of the information officer. Once an appeal has been submitted, the information officer has a duty to acknowledge receipt of the appeal and to notify the parties that an appeal has been taken. The next video will detail the steps that can happen when an appeal is submitted.